slightly disappointing. But I do know that we've had certain issues with
Should
my
we put
module
it off till
system.
another time? It doesn't seem worthwhile for one or two people.
Mm, mm. No, I think it's more an issue around the my module system being unstable and not sending out announcements. And it might just be that it's linked to that. I did send a reminder out yesterday to
Yeah.
let them know of this class. So they knew that it was coming, of course, and I sent out a reminder yesterday. So I'm hoping that more of them will join as we progress in this discussion. Um, we do record it so that the students can watch it after the fact.
Yeah.
It is disappointing to.
Just doesn't seem worthwhile talking to one one person.
No, it's.
So,
Do you want to wait to see until 12:45, or would you like to then
no, I
just
need
flow
to
ahead?
get on with it because I've got other appointments.
Okay, great. So of course, this is an excellent talk, and you give it so well every year. Insurance law and the Bill of Rights is an incredibly new and interesting area in insurance law. I think that the students will benefit tremendously from your presentation and your thoughts on this knowledge of insurance law.
I didn't hear that.
I just wanted to say welcome, and I think the student can hear me, so I just wanted to give an introduction to insurance and bill of
Okay.
rights.
Can I go on and
Yes,
get on with it?
yes, please, yes, please, sir.
Okay. Okay. Well, welcome whoever is listening out there. Can I just start by saying that when we talk about the Bill of Rights, and it's perhaps a bit broader than that, and interestingly enough, if you see that date on the slide there, 26 October 2021, it's exactly a year to the day since I gave this similar talk last year. There have been a couple of cases since then, but nothing has changed much in the issue of the effect of the Bill of Rights on insurance. People are very quick to say, ever since 1994, in fact, it's unconstitutional, but you've got to bring it within limits and within the rights that appear from the Bill of Rights, particularly. There's a couple of sections in the Constitution itself which affect how we deal with insurance. But I've got in front of me, there's a whole page of
I rule of.
information regarding about the different sections in the Bill of Rights that affect insurance. And the first thing to say is that there's no hierarchy of rights, there's no absolute right, and there's no right necessarily trumps another. Although the Constitutional Court has said many times that perhaps our highest value is dignity, and that will come into it as you'll hear later. But you've got to look at all these rights and see how they work in relation to relationships between insurer and insured in particular. And the starting point, as you will know, let me just go back a little bit because I find that even with some of my colleagues in my office here, people do not understand the point that the Constitution is the supreme law and that it says law or conduct inconsistent with it is invalid and the obligations imposed must be fulfilled. It's been called the cornerstone of democracy in Section 7. And when you do any thinking as a lawyer, no matter what department in labor law, constitutional law, competition law, lending law, whatever it is, you have to know that the Bill of Rights is a supreme law and that it might affect a document that you draft, a letter that you send, or advice that you give to a client or your employer if you're in employment. And let me say that the best way to start is at the end of the Bill of Rights, towards the end of the Bill of Rights, and that is Section 36, which is the so-called limitation clause. And it says that you can limit a right in the Bill of Rights if it is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. And of course, because it says you can look at it in the relation to an open and democratic society, it means you can look at how public policy works throughout the world. You can look at other jurisdictions which have Bill of Rights or which apply human rights and maybe apply the 1948 Treaty on Human Rights. So it does expand it, and you'll know, I'll come to it later, that the Bill of Rights specifically allows you to look at foreign law. And of course, in relation to insurance, insurance really developed mainly, although if you look at J.P. van Niekerk's writing, you'll see it comes from long Roman Dutch and even beyond that, the whole concept of indemnity. And it's a contract of indemnity which is dealt with in Roman Dutch law and needs to be looked at. But you've got to look at the fact that we've absorbed a lot of our insurance law from the UK, from English law to be exact. And nowadays, if you've ever looked at my blog, you'll see that I draw resources from the USA, from Canada, from the UK, and from Australia. They all have active courts dealing with insurance matters. And if you look at them, you'll find the policy wordings are similar. So you can look at things in relation to other open and democratic societies. And Section 36 says when you're deciding whether you can limit a right, you've got to look at the nature of the right. And obviously, you can't limit rights like equality. If there's unfair discrimination, you can't limit that right. You can limit fair discrimination, but not unfair discrimination, because that's a cornerstone. And you look at the importance and purpose of the limitation. And let me put it in the context, if you look at the purpose, then you look at the contract and you see what it is. If it's a liability policy and you're insuring somebody for their liabilities to a third party, you can't load it with exceptions which take away the rights for your own negligence, for instance. That's what liability policies do. Directors and officers policies do. They protect you against your own negligent conduct. So you can't say, I won't pay you if you're negligent, because that undercuts the purpose of the insurance and the nature and extent of the limitation. And then there's always, are there less restrictive means of dealing with the issue? And I'll come to the Barkhuizen case, but you might say your policy says you must institute action within 10 days. There's a less restrictive way of dealing with it. You can make it 3 months, as was the Barkhuizen case. And I'll come back to the Barkhuizen case because it illustrates a lot of these points. The other thing that you'll know about the Bill of Rights is that it specifically says, Section 36, Section 8.3, that the courts can develop the common law to extend rights. And a typical example of extending the common law is the situation of enforceability of contracts. I'm not talking about void contracts. I'm talking about the rights that the courts have always given to themselves to not enforce a contract if it is against public policy, because the courts are not there to do bad things, they're there to do justice. So there's many cases where the court says, I refuse to enforce a policy. You might remember there was a case in KwaZulu-Natal where a bank had foreclosed on a mortgage bond when the people had been paying for years and years and years, and I think they owed about 200,000 Rand from what had originally been a very big bond, and the courts tried to foreclose the bond and sell the property, and the court said they weren't going to enforce it because it was unfair that they could take the money for 20 years and then enforce a right, although on paper it was enforceable. Now, when you deal with enforceability, it's a question of public policy as seen by the court. And we know that from 1994, the cornerstone of public policy is to be found in the Constitution, and more especially in the Bill of Rights, those rights about dignity, equality, freedom, etc. So they come into court cases all the time. If you, not only obviously insurance law, but it's an important aspect of insurance law. It also recognizes legislation, common law, customary law, which doesn't have a big role to play in insurance cases that I've come across, but there's no reason why, if something were against a custom, and I'll tell you where it comes in my experience. Uh, in relation to, say, a funeral policy, and they say that you can insure a dependent. If you look at traditional cases many years ago, they would say a dependent is a family member who is a wife, a child, a nephew, or something. Whereas in cultural law, a dependent may be somebody who's not necessarily even related to you. It might be somebody because of a cultural situation you have taken on the obligation as a dependent. And so you can't always just go to family connections and blood connections and say that is a dependent. And that's a very good example of how cultural law can cross over into the definition of a dependent. So the other thing that I want to draw your attention to is section 172 of the Constitution itself, because that's the section that says that the courts can make an order that is just and equitable. And the courts more and more frequently use that section in order to give justice between parties. You will have seen it in many cases where they say, I'll tell you where it's come in quite often in relation to the tender cases, where tenders are set aside because of corruption or something. They often make an order which is just and equitable, because it might have been an unlawful tender, but the building or the stadium or whatever it is now three-quarters built. And to say I'm going to declare it void from day one, as the common law would say, would not help anybody. So they make a just and equitable order. And that comes into insurance law particularly, because it's a just outcome for an obligation by the insurance company to indemnify. The other thing you must bear in mind in this regard is that when you go to court and you challenge something, you can't always knock on the door of the Constitutional Court. The Constitutional Court will only deal, according to its section 167, matters which are constitutional matters and there are arguable points of general public importance. And they often take on issues on that second ground, arguable points of general public importance. But you won't be able to take an insurance dispute, which is a purely factual dispute between you and your insurer, or acting for the insurer, between the insurer and the client, which is just purely factual and has no general significance at all. You won't get to the Constitutional Court. They won't have jurisdiction, and they won't accept jurisdiction for a fight like that. Your stopping point will be the Supreme Court of Appeal. And the other thing to say is that where you've got issues of general public importance, it may be that the courts can look broader than just the wording of the policy itself. You know, I'm of a generation which saw what was known as the golden rule of interpretation. The golden rule said you look at the words and you interpret them according to their ordinary meaning, and that's what the parties meant. And I started writing an article about 20 years ago saying the golden rule should be dead, and finally I suppose about 10 years ago, a bit more, KwaZulu-Natal case, the courts finally set it out that when you look at a contract, and the insurance policy is a contract like every other, you've got to look at the purpose and the context in which it was entered into. And that was extended even further. There was that recent University of Johannesburg versus Auckland Park Theological Seminar, where the university had sold a part of their land and was supposed to be used for educational purposes. And what the purchaser wanted to do was to use it for other purposes, not educational. And they tried to, and the university set it aside eventually with the help of the Constitutional Court. And they went much further than ever before, not only looking at context and purpose, but they looked at extrinsic evidence and cut quite deeply into what we know as the parole evidence rule. So really what I'm saying is that these things are flexible, and you can't just look at the ordinary language as lawyers over 40 tend to do. I suppose young students these days must be looking at the proper way of interpreting contracts, which tries to get to the purpose that the context in which it was entered into, so that the parties don't get lumbered with an interpretation which may look like that on ordinary language, but is not what they intended at all. Now, let's look at interpretation of insurance contracts. I should have been giving you some slides here, although they're very limited. But let me just give you, this is what I want to give you. Centrique versus Oosthuizen, it's the leading case now that is always quoted in interpretation of insurance policies. It's a 2019 case by the Supreme Court of Appeal. And Centrique said what you see there. Firstly, that a policy of insurance is a contract like any other contract. And I can tell you now, when I was a much younger insurance lawyer, the only South African textbook was called Gordon and Getz, the South African Law of Insurance. And it was very English law based. And there's a lot of English law which still persists, which kind of isolates insurance contracts as some special form of contract. Although even in England now, that's dying. If you look at the Supreme Court judgments there, but in Roman Dutch law, contracts are contracts, and all those principles that apply to contracts that come to us probably from Justinian's time apply to insurance contracts. There are some special rules about exclusions and warranties and so on, which we'll come to. The second thing that Centrique said was that you've got to give a commercially sensible meaning to a policy. It's no good looking at the letters that the insurance company wrote down in their policy and coming to a conclusion which simply doesn't work. Then the third thing they set out, which is also pretty obvious, the document must be looked at as a whole and the factual background. Now that's the very thing we were talking about, and that is you've got to look at every contract in relation to its context. What was the context in which it was entered into? I don't know if you remember, it was nothing to do with insurance, but the first case where this particularly came out, where there was an ambiguous contract between two brothers, and on one interpretation, the one brother was giving a lot of benefit to the other brother according to the contract. On the other interpretation, there was no such passing of benefits between brothers. And the court looked at the fact that the brothers hated each other or disliked each other. I can't remember how strongly it was. And said, look, in the context of the relationship between these two brothers, the one would never have given all this benefit to the other. It was to do with sand, I think. So they looked at the context in which the contract was entered into, namely the enmity between two brothers, in order to decide which ambiguous meaning they would apply. Then the fair and sensible application, I suppose that's not unlike commercially sensible. Ambiguity and exclusions are interpreted against the insurer. This is a product of the contra proferentum rule, which said that contracts are interpreted against the person who drafts them. And inevitably, in most contracts for individuals, you'll find that the insurance company drafts the contract. But that has moved on enormously. If you go to the very big broking houses like Aon and Marsh and Willis, they are international broking houses. They have their own policy wordings. And what they do, they say to an insurance company, they say, look, I've got this policy wording. I've got a bank of 10,000 policyholders, and I'd like to bring them all to you. But you have to apply my policy wording. So it's not always the wording of the insurer, but nonetheless, the courts say if there's an ambiguity or if there's an exclusion, we will interpret it narrowly against the insurer. Because if you enter into a contract of indemnity and you want to exclude something from it, You have to make it clear what you're not giving the particular person. And then the final point was a very important one that they made in Centrique. They said, we will not construe exclusions in favor of the insured simply because they're unfair or unreasonable. If the plain wording of the exclusion and its context and purpose is clear, and it excludes some obligation of the insurance company to pay a claim, then they won't say, well, it's unfair that you included this. If it's plain language, unambiguous, and not against public policy, they will exclude it. And if you look at a motor policy, there's exclusions about the vehicle being you won't get paid if your vehicle is unroadworthy. And what the courts have done with that kind of exclusion is they say that it has to be an element of causation. For instance, if your car is unroadworthy because you haven't changed the tires often enough and it hasn't got X amount of thread according to the road traffic legislation, but your car gets stolen from your garage or from a parking lot, the courts won't say, well, claim doesn't have to be paid because your car wasn't roadworthy. The tires were smooth, because there's no causation, there's no causative effect between the smooth tire and the loss of a vehicle. So it's always got to be looked at in some sort of fair, sensible, and reasonable fashion. And causation is always a point. Every now and again, the insurers stick in an exclusion which is completely contrary to fairness, and the courts just don't uphold them unless there's a cause and effect involved in it. And I make the final point there, there's only one system of law in the constitutional democracy, and that is as I say, the law of contract. We don't look at it like sometimes you see in the UK, where they say, well, there's some special laws for insurance. And I had an example of that recently. It's in relation to where there's an exclusion in the policy and also a clause which says the claim is payable. And the English fall back on an old case called Wayne Tank. And it says that if there's an exclusion, then it overrides the indemnity clause. If there are two causes, for instance, if there's two things contributing to the loss, the excluded clause will override the covered clause. We don't think like that. If you look at Reinecker and his fellow authors on insurance law, you'll see we apply the ordinary principles of Roman Dutch law in regard to causation, and whether there was a break in the chain of causation, whether there was a new intervening cause. We don't have strict rules like Wayne Tank, which has never been applied in this country. It was once referred to in the Eastern Cape, but it was overturned, it was wrong. So we go back on Roman Dutch principles. And the beauty of it is that, I mean, if you look at Reinecker and others on insurance law, it's very much Roman Dutch law based. And you've got to be quite careful of looking at English law and just applying it straight down the line. And I still have, I mean, in the very Wayne Tank case, I briefed some senior counsel recently and they quoted Wayne Tank to me. And I said, well, that's not South African law. It might look like it. And don't go digging in the bookshelf and getting out Gordon and Getz or something which is based on the wrong principles. Now, the main case was Barkhuizen versus Napier. This was the very first insurance case that went to the Constitutional Court. And I'll tell you something interesting. Professor J.P. van Niekerk and I rushed off together to watch the case in action because it was the first case. And we were both quite disappointed because the counsel who were arguing and the judges who were listening to it didn't have much intrinsic knowledge about insurance law, although the outcome of the case after deliberation is fair and correct, but it wasn't a very inspiring hearing. Anyway, Barkhuizen versus Napier was a case where there was a provision in the insurance policy which said that if the insurance company rejects your claim, you've got to institute action within 3 months, otherwise your claim falls away. It's a contractual limitation, not unlike a prescription clause, but it's a contractual limitation of claims. And it went all the way to the Constitutional Court because uh, Barkhuizen had not instituted action within 3 months. And the insurance company rejected the claim. Incidentally, the reason that it's Barkhuizen versus Napier is a interesting situation because Napier is Ronnie Napier, who was the local representative of Lloyd's of London. Lloyd's of London are entitled to insure in South Africa as long as they put up a deposit here to cover their claims. And the law says that if you want to sue Lloyd's of London in South Africa, you serve it on the local representative of Lloyd's of London in South Africa, and happened to be Ronnie Napier at the time. So for Napier there, you can read the underwriters at Lloyd's of London. Anyway, the first thing that the Constitutional Court, what Barkhuizen said was that I have rights under the access clause, access to justice clause, which says I'm entitled to a fair public hearing before a court. And Barkhuizen said, this is not a fair public hearing. It's unfair to make me sue within 3 months when the prescription period is 3 years. The other issue that arose was the question of freedom of contract. And the insurance company, needless to say, said, well, you entered into the contract, it had this clause in it, and you bound, according to South African common law, by what you sign. And that was upheld by the court, not the outcome, but the Constitutional Court did something very important in Barkhuizen versus Napier. They said that the obligation to abide by a contract which you freely and voluntarily enter into is a principle of South African constitutional law. It's not written in the Bill of Rights. You won't find a section in the Bill of Rights which says if you enter into a contract, you're bound by it according to common law. But they said that society cannot operate properly if people are not bound by what they sign, and the economy will fall apart. And it's a constitutional right to say to somebody, you entered into a contract with me and you are bound by it. They can't fall back on some principle of fairness or equity. Then that third bullet, equality and dignity, regarding the relative bargaining position. It's important that Barkhuizen had a insurance broker acting for him. Now, insurance brokers under the FASE Act, the Financial Advisory Intermediary Services Act, are supposed to be qualified. There's requirements of competence and integrity in the Act. And if you've got a broker acting for you and there's a plain clause, as in this case said, sue within 3 months, you can't go to the Constitutional Court and say this is unfair to me because I didn't notice it or it's not fair. But Barkhuizen didn't say that every time there's a 3-month clause, limitation of action clause in a policy, that it's binding on everybody, because in a different situation where somebody who has limited literacy skills or illiterate even, and somebody's sold a funeral policy by some what they call foot soldiers in the street, or in a telephone call by a call center, and somebody with a limited understanding of things, then maybe it will not be upheld by the court. They may say that in those circumstances, you've got to realize that people don't have ready access to law and lawyers and brokers, and that's not a reasonable term. I'm not saying 3 months is not reasonable. And by the way, the 3 months in this matter wasn't 3 months from the date of the event. It was 3 months from lodging your claim, getting the insurance company to respond to your claim, and the policyholder protection rules give you another 90 days to argue with the insurance company, and then they give you a final decision. So it's not like it was have your accident and sue me in 3 months. Or there was a whole claims process before the 3 months started running. And the next bullet says that the next two bullets, they apply public policy, but public policy tolerates time limits in contracts. There are many, many, many thousands of contracts which have a time limit saying you've got to do X in a certain amount of time. If you want to go to arbitration, you've got to let me know within 6 months of the dispute arising. If you want to go to court, you've got to do it within a year. And it's often quite important, by the way, because insurance companies have actuaries and they've got solvency requirements, and they've got to know from year to year what their claims ratios are. And they don't like open-ended claims that just keep the claim open, keep it in their reserves for another 3 years in case Mr. Barkhuizen decides to sue. So they say, I'll give you 3 months because then I'm going to take it out of my reserves and get on with using those reserves for other insurance. So there's good rational commercial reasons to go back to the Centric case. And that last bullet is the clause unreasonable and should it be enforced in the circumstances. That little phrase in the circumstances, they gave examples, for instance, if somebody is injured in an accident and they are in hospital with a head injury and unconscious for that 3 month period, the court might not uphold it. They might say, well, in that situation, they were unable to enforce their rights, so we'll give some latitude until a curator is appointed or whatever the case may be. And as I say in the next bullet, the principles don't only apply to time limitation clauses. Barkhuizen is referred to in many, many cases relating to insurance and the Constitution. And it is worth going back because you've got to go through those things. There was a case only yesterday involving Capitec where they referred to Barkhuizen versus Napier and the principles that you apply in order to get to the answer, is it or is it not against public policy and enforceable under the Bill of Rights and say the access to justice clause. And it pops up all the time, but Capitec versus somebody, I can't remember, came onto my screen yesterday dealing with that very point. The second last bullet there, I say COVID cases, there was an element of fairness. When I say the COVID cases, it was those cases for the hospitality industry. People got insurance and it said, if an infectious disease breaks out within 25 kilometers of my premises, and as a result, I'm a seaside hotel and everybody stays away, then there's a business interruption claim under the policy. And there's not only infectious diseases, by the way, there's shark attack. And you might have seen in Plettenberg Bay recently, there were 2 shark attacks and everybody's waiting for December to see how many tourists will turn up. But so in the COVID cases, the issue was this, the insurance companies said, well, there was an outbreak within 25 kilometers of your premises, but that's not the only reason that people didn't come to your restaurant, because it was throughout the country. Nobody was traveling from Joburg to Cape Town anymore. Nobody was traveling across borders provincial borders, and everybody was closed out. So only those losses that you can ascribe to the 25-kilometer radius need to be paid. And the court spread out the proximate cause test to say that you look at the peril, and the peril is the disease, and the disease was countrywide, and therefore all the losses that the restaurant or hotel, for instance, suffered were covered under the policy. And it's an extension in the Cafe Chameleon case of the proximate cause test. One of the senior counsel in England, where they had the same outcome, called it a sleight of hand, but it is a development, and it's a development of the common law of proximate cause in the context of these particular COVID cases. The last bullet on that slide is that good faith is not a self-standing rule of the law of contract. The court said it in Judicia 231cc versus the Trustees of Oregon Trust, and that was a 2020 Constitutional Court decision in which somebody tried to say, well, this whole contract was not, or the enforcement of the contract was not done in good faith. And the court said there's no overriding good faith principle of entering into a contract. If the contract is voluntarily and freely entered into by parties who have advice, then you're bound by the contract. And if it has a bad outcome for you, you should have noticed that. And funny enough, in the Capitec case recently, that argument was presented to say that the, the clause in the contract had a particular meaning because the court had to look at the fact that the people who were trying to persuade the court that it had that meaning were the BEE element of the transaction. And they said, you've got to look at this in a very special way because we are disadvantaged. But the court said, well, you spent, and this is an outrageous figure, I don't know what they spent it on, but you spent 16 million rand on legal advice. So don't tell us that it wasn't a good faith contract that you didn't understand. Your lawyers, your 16 million rand legal advice should have told you what was in it. But that's a good example of how, good faith is not a self-standing thing. You can't just say, well, I'm poor or ignorant or was out of the country or something when there was no reason why that should override the actual terms of the contract. The next thing I want to remind you is that the Equality Act has to be looked at. The promotion of equality and whatever, I call it the Equality Act. And it deals with discrimination, and you'll know the Equality Act goes a bit further than the Bill of Rights itself. The Bill of Rights has got in Section 9 the various grounds of discrimination that will not be permitted unfairly, of course, not unfair discrimination. And the Equality Act goes further, and they talk about any other systemic discrimination is forbidden. But the Equality Act tells you how the thing unfolds in the courts. If there's, on the face of it, discrimination, and there are plenty of examples of that. For instance, drivers under 23, especially male drivers, pay a higher premium than over 23. People who've had their license, so that's an age discrimination on the face of it. There's a policy out there in the market called First for Women, which has special policy provisions for women and a lower premium because they have a better accident record. And no male could say, well, look, I want to be in that policy because otherwise you're unfairly discriminating against me. But if it were challenged, then the burden is on the insurer to show that the discrimination is fair. And what is interesting about the Equality Act, it says in Section 14, it's objectively determinable criteria intrinsic to the activity concerned. Now, that's a lot of long words, but what it boils down to is this, is that if the insurance company can show that objectively there's a good reason for charging a higher premium for male motorists under the age of 23, then that is not unfair discrimination. So the actuaries will go out and they'll produce the figures and they'll say, look at the figures, the accident rate for 21-year-olds is outrageous compared with 31-year-olds, and we're therefore entitled to charge a higher premium. It's not age discrimination, it's an objectively determinable criteria. So what sometimes on the face of it looks like discrimination is not. And if you look at a lot of life policies and funeral policies, they say you can't take out a policy over the age of 65. And to my knowledge, that sort of thing has never been challenged. Nobody said that's age discrimination for a 66-year-old, because the actuaries will say, well, we can't have all our people over the age of 65 because they won't live long enough as a class to pay enough premium to make the product economically feasible. And an insurance company has to be solvent and has to have products which are economically feasible. Section 29 of the Equality Act has a whole schedule refers to the schedule attached to the Act, which has a whole long list of things which are deemed to be discriminatory unless they shown to be otherwise. And let me just look at those. For instance, it says you can't, let me just find it, unfairly refusing to make insurance available on prohibited grounds. You can't say, well, I'm not going to sell this policy to somebody who is black or white or gay or whatever the case may be. You can't have those kind of grounds. And it's sometimes quite subtle whether it is or isn't. There was a controversy many years ago where the banks were not giving mortgage bonds to people in certain suburbs. And that was highly criticized because obviously if you look at the division of suburbs, then all the people in the rich suburbs got insurance and the people in the poor suburbs couldn't, and it was said to be discriminatory. It didn't go to court, but I mean the publicity was so strong that it was not allowed, and the banks backed down. It was called redlining, and you can't do redlining in insurance either. You can't say, well, look, I'm not going to give fire policies for that area because the people haven't got as much money as another area, so their fire control is not good. You can't do it on a basis like that. You can do it on the basis that's next to a forest, which is a high fire risk, or that the house is got a thatch roof, which is a high lightning fire risk. You can refuse on proper grounds, but you can't refuse on discriminatory grounds. It also says in section 29 in the attachment that you can't discriminate solely on the basis of HIV and AIDS status. That may be unfair. Now, there are many policies that which say if you are HIV positive, you won't get insurance, but that's not discriminatory without an objective criteria. I mean, there are many policies which say you won't get insurance or you'll pay much more if you smoke, or if your drinking habits are poor or so on. You can always have objective grounds, but you can't draw a line through and say, I'm not insuring anybody, particularly in this age with HIV, where HIV is controlled by drugs. And that won't work as a broad range of discrimination. The other thing that always occupied my mind is that many policies, life policies and disability policies and accident policies, they used to have an exclusion which said they won't pay for any event as a result of pregnancy and childbirth. Now, that to me is a discriminatory exclusion, because you can say I won't pay for some unusual consequence, but just to say I won't pay for anything resulting from pregnancy or childbirth is undoubtedly discriminatory against women who give birth. And it's been in many policy. I think it's disappearing slowly. It hasn't been challenged officially, but one's got to be careful and keep your mind on the Bill of Rights at all times when you are entering into a policy or interpreting a policy. So, I mean, that's my talk. I just want to make the point that everything is based on the Bill of Rights. It's the cornerstone of democracy. It is something that has to be borne in mind, and the courts will bear in mind, and that when you're arguing a case or interpreting something, you have to bear in mind all those provisions that I mentioned out of the Bill of Rights to see that they are not intruded on. It hasn't been a big feature in litigation or challenging insurers that I know about. You know, when the Constitution, Bill of Rights first came into force, I gave talks on the effect of the Bill of Rights on insurance, and probably went too far, suggesting that some of these discriminatory practices between male and female and old and young were not going to be sustained. There hasn't been a big challenge in that, but the insurance industry has moved forward. They're not the wicked industry. They pay out zillions in claims every year, and they've moved forward on plainer language. The exclusions are diminishing. any exclusion that looks discriminatory, I think is no longer there. When I was young, every policy had a suicide exclusion. Nowadays, it's a suicide exclusion for the first 2 years, so you don't take out a life policy and bump yourself off to give your spouse a nice big sum of money. So they give a 2 year break, but it's no longer an absolute no-no because suicide is often the consequence of mental illness, not just of some aberration in the person trying to get some money out of the insurance company. So you don't want to discriminate on the grounds of mental illness because the bill doesn't allow that. So times have moved on, policies have got better. The wording is sometimes plainer. I'm a great proponent of plain, ordinary language. They're not always as easy as that. Some of the wording goes back centuries, so it is what it is, and it's been interpreted. But generally, you just got to look at that, and the whole phrase public policy, I suppose, is the umbrella. Is it according to public policy? And the public policy is going to be determined according to what's in the common law, what's in the head of the judge at the time, and most particularly what is in the Bill of Rights. Does it fit within our cornerstone of democracy? Thanks. Are there any questions or comments?
Um, um, Bonabi, do you have any comments or questions? You're also having trouble with your mic. I see him typing. Patrick, I will ask you for your PowerPoint. I'd love to put that up
And
on the
I
screen.
can't hear you.
I'm going to ask you for your PowerPoint presentation. If you could email that afterwards.
Yes, I can send you that easily.
Thank you.
I'll tell you what I'll do. I'll also, I've been working from notes, and I'll send you those as well because that's got the detail.
Oh, wow.
So, it's all there in quite full form over 3 pages. I'll send you both.
I see the student has written in the chat just to say thank you very much. He's also seemingly struggling with his mic, so it's not just me. We can
Yes,
hear you
yeah.
clearly, but that we can't, it seems,
Yes,
with
I
the
can hear you now. It's a bit thinny, but anyway, I'll, Rafi, in my Cape Town office at the moment, I'm leaving just now for the airport, so it might take a couple of days, but I'll get you the slides and so on.
Thank you very much. Thank you.
Good.
Thank you for making time. I really appreciate it.
No, it's always a pleasure to help you. Nisa, as you know, I graduated out of there a few centuries ago, so it's fine.
Thank you very much.
Good.
And have a safe flight.
Thank you. We'll talk again. Thanks. Bye-bye.